Good afternoon. Welcome. Thanks for coming. And for those of you on the webinar, I'm told that you will not be seeing us, but you will only be seeing the PowerPoint slides. That's a shame because I can assure you that I look a lot more like Cary Grant in person. I'm Fran Deisinger. I'm one of you. I'm the General Counsel at Reinhardt. I have been in this role for 7 or 8 years and effectively in this role for probably twice that long, just 7 or 8 years since we adopted the General Counsel nomenclature. I also represent private clients when I'm not trying to settle down a barrel of 200 monkeys, otherwise known as my partners. We're also going to have on our panel today, I think, flying in at the last moment, Mark Camelli. Mark's not here yet because he's trying to race in from the airport. He was in New York the last few days visiting his daughter for her 21st birthday. Mark's the leader of our internal investigations and corporate compliance practice, and assuming that he can make it through the fog, he'll be playing the John Madden role today, which is to say he'll be the color commentator, providing some astute analysis and comic relief. And finally, the last person on our panel today is Kate Maternowski, who's sitting next to me. Kate will be playing the role of the smart member of the group. And as you can imagine, as one of our bright young litigators here, she is mostly responsible for the substantive information that we're going to try to present to you today. I've also asked her to kick Mark once he shows up if he says anything stupid. So let's, you've seen this slide and you've seen our pictures and bios, and I'm sure that's fascinating to you, but we'll move right ahead. First of all, webinar housekeeping, which is in here somewhere. For those of you who are watching this on the web, there are some indications here as to what you need to do if you want to ask a question and how to adjust your screen, like the Twilight Zone used to tell us, or maybe that was the Outer Limits, I can't remember. So if you have any questions, please send them to Nancy Posgay at the email listed here. So what are we here for today? We're going to be talking about problems unique to in-house counsel. I don't need to tell you this, but you all have one client. That client acts through human representatives, but you have one client. You yourselves are employees of the client, which puts you in a fairly interesting and sometimes awkward position, as it does for me. Sometimes you're involved in both legal and business matters, and that also can present some situations, including conflict situations, particularly if, for example, you are expected to be or asked to be a member of the board of directors. Nevertheless, notwithstanding your rather different role than for those of us in private practice, you're subject to the ethics rules just as we are. So today we're going to talk about some situations, some issues that are, we think, particularly pertinent to the in-house counsel role. First, who is the client? Second, under what circumstances can you or must you report your client's misconduct, which is to say your own employer's misconduct? And that's really a species of a larger question in the law of attorney ethics of when you can reveal confidential client communications. Next, what's the so-called corporate Miranda warning that you may be required to give in certain circumstances to employees of your organization? That's closely related to the who is your client question. We'll talk about under what circumstances lawyers not licensed in Wisconsin can get licensed in Wisconsin. Some of you may be at organizations, I'm sure some of you are at organizations that have operations here in Wisconsin, but that recruit lawyers from other jurisdictions for particular in-house roles, and in some cases, I know this from experience, some of those lawyers have not yet been licensed in Wisconsin. Well, there is a special rule in Wisconsin that allows that to occur. We'll talk about serving on boards, about the interesting problem of what happens or what obligations you have when you resign from your position or leave your position as an in-house counsel, and some particular problems regarding looking at employee emails, which is something that you may be asked to do on occasion, as I am asked to do on occasion. Finally, we're going to talk, if we have time, I'm not sure that we will, but we're going to talk about the Wisconsin disciplinary system, something I hope none of you have actually been involved in personally, but it's possible that you have been. And we'll give you a quick primer on that. Obviously, this is a lot to cover. I'm not sure we're going to get through it all. At the end of the presentation, for those of you here in person, we're going to either give you a written examination to complete, or if you've been very good, we may just move out to the large conference room and have a beer. So be good. All right, organization as client. First of all, let me remind those of you who haven't had to think about this in a while what this designation means. Supreme Court Rule 20:1.13. This refers to Chapter 20 of the Supreme Court Rules of the State of Wisconsin. And Chapter 20 of the Supreme Court Rules of Wisconsin are the rules of professional conduct for attorneys. I keep this, you can't see this on the web, I know, but I keep this dog-eared, now held together with, staples, copy of the rules here. And when you work in a place like this, you go through those a lot in my job. I also have the annotated model rules of professional conduct from the ABA, on which the Wisconsin rules are based, but they're not identical. I use these a lot as well. And here's my Wisconsin statute book. Chapter 20 shows up in the back after all the important court statutes. I get to know these things very well. So Chapter 20 are the Supreme Court rules on professional conduct. And they are every lawyer in this state who's licensed in this state or who practices in this state. They are our rules. Rule 1.13 is the rule called organization as client, and talks about that relationship between the lawyer and the entity. And just as for us in private practice, if we're representing the ABC company, we're representing the company, so do you represent the company. Now here's a quick question. Have you ever had an executive of your organization who thought you were his lawyer, or who didn't see the difference between you representing the entity and representing her? Sometimes, many times, these interests are aligned between executives or constituents within an entity and the entity itself, but they're not the same. There is still a distinction. The entity is your client. In our practice, it's very common for our lawyers to refer not to the entity that they are working for, but to the person that they are working with. Whether that's an executive or an owner, usually it's one of those people. I can imagine that is the same phenomenon that you encounter in your in-house practice all the time. You think of your fellows in the organization, the executives in the organization, as your clients. You even refer to them, I know, as my internal clients. And I do the same thing here. Those are my internal clients. But in a way, they're not. They are people who act on behalf of your clients, because no entity can act on its own. It acts through humans. And that's why you're dealing with them. But they're not your client. Corporations can only act through their human constituents. And you have to consider, no matter what kind of advice you're giving and no matter to whom you are giving it, you have to consider the ends and goals of the organization and the obligations that you have to the organization. Kate's going to talk about some sample cases of regarding specific issues that arise because of the entity rule in Wisconsin and throughout the country.
Sure, thanks, Fran. I'm going to start with this case, Jesse v. Danforth, the Wisconsin Supreme Court case that's pretty basic and highlights this rule that Fran's been talking about, the entity rule, that a lawyer represents the entity and not the individual constituents of that entity. In this case, a law firm sought to represent two patients in a medical malpractice case against physicians who were shareholders of a corporation that law firm had previously represented in its incorporation, worked for that company and setting it up as a corporation. And the defendant physicians challenged the law firm's representation of those plaintiff patients in that case on the ground that the law firm had a conflict of interest because it had previously run this company for whom the doctors were now shareholders. And the court held that the entity rule applies here, and so that the physician shareholders couldn't claim a conflict because the law firm in its representation of the company for the incorporation phase represented just that, the company, which then became a corporation, and not the individual constituents. And so now when the law firm sought to be adverse to individual constituents, in this case doctors of the corporation, there was no conflict, and the court allowed the case to go forward.
Now, if you think about that case, it's really quite a powerful statement about the importance of the entity rule, because what could be clearer than that a couple of physicians in a fairly small medical practice who have malpractice cases against them, but somehow that isn't going to affect the entity itself. And yet the court decided that because the prior representation was of the entity, not of the individuals, that the lawyers could go ahead.
This next case has to do with attorney-client privilege and the entity rule. Lane versus Sharp, a 2002 case, also the Wisconsin Supreme Court. In this case, a former corporate officer and director of the Sharp packaging system contended that he was entitled to certain documents because either for one of two reasons, either because he could waive the lawyer-client privilege because he was a former director of that company, or because he was entitled to the privileged communications because he was a director at the time that they were made. And the court held that this isn't so. The court rejected his contention because a former director doesn't have the ability to waive the privilege that belongs to the corporation. Even if he was a director at the time that this case was brought, one director also doesn't have the ability to waive this privilege. The privilege belongs to the corporation and not to him individually.
As you can imagine, this can be a very important shield for an entity, for a corporation, in a situation where there's been a falling out. And I'm sure you probably all have experienced the occasional falling out in your entities. Executives leave, directors leave, sometimes unhappily, as was the case in Lane versus Sharp Packaging. The fact that a former executive or director or officer cannot waive that privilege on behalf of the company is extremely important. And just as I'm saying that, I want to introduce Mark Camelli, my partner, and I'm going to throw this directly to Mark Camelli. Mark, we have just discussed the issue of Lane versus Sharp Packaging, in which Mark's trying to remember the case now, in which it was ruled that a former director of a company cannot waive the privilege. And I know you've had some interesting cases on behalf of clients in which the issue of who owns the privilege has become hotly debated. So we're going to sit you down on a microphone here momentarily.
It has been, and particularly, it's been a particular challenge where a company and its officers, directors, are both as an entity and individually targets of, for example, a civil enforcement action, criminal investigation, and there may be advice of counsel involved that is helpful to the individuals, and I have something like this right now, and the company doesn't want to waive the privilege and has told the officer or director it's ours to waive. And so it puts these people individually in a trick box. So we're still in that, but we're working our way out of it, I think.
In those situations where Mark is representing the entity, that's a nice shield to have. In those situations where Mark is representing the individual whose interests now perhaps are not aligned with the entity, it creates a bigger problem.
Correct.
Why don't we go ahead to derivative actions?
Sure. This next case, Einhorn versus Kalia, 2000 case, had to do with, like Fran said, derivative actions. In this case, a minority shareholder brought a derivative action, and Northern Labs, the corporation, formed a special litigation committee to evaluate the merits of the derivative action, and ultimately determined it was not in the corporation's best interest. But this case involved whether or not that special litigation committee was independent. And as you might know, its independence is a requirement in order for the committee's decision to be viewed as a proper exercise of the business judgment rule. And so the issue before the court was whether or not the presence of in-house counsel at the meetings of the special litigation, special litigation committee made it so that that committee was not independent. And there wasn't a lot of fact-finding in this case about just what role the in-house counsel had in relation to the special litigation committee, how extensive the in-house attorney dealings were with the committee. But the court said some important things regarding these kinds of committees and in-house counsel's roles. The court said basically it's a fact-based analysis. It's going to be a case-by-case thing. That the role of the corporation's counsel should be considered as one of many circumstances in determining whether the committee is independent. And some states take a harder stance than others, but it's ultimately a case-by-case determination. So the comments to the Wisconsin rules that Fran's been talking about address in some way derivative actions like these and say that basically if the claim involves serious charges of wrongdoing, that's the situation in which it might not be wise to have in-house counsel advising the special litigation committee. That in that case, there might be a conflict between the lawyer's duty to the organization and the lawyer's relationship with the board. And so in that circumstance, you might want to consider getting independent counsel, or at least considering that question and advising the board of this potential conflict.
So the Einhorn versus Kalia case didn't settle the issue of when you need to get independent counsel or when you need as in-house counsel not to be part of that investigative committee, but it raised it, it flagged the issue, and what it really comes down to is we now know there's a tremendous risk for in-house counsel to sit on such a committee. Mark, a lot of your practice is assisting entities with respect to internal investigations. What's your experience been?
Well, we have actually played the role of counsel to a special litigation committee, and I find that particularly public companies are sensitive to that because they want the independence role, and so that, I think, in terms of a belts and suspenders approach to appropriately reviewing derivative claims, that is probably viewed as probably the most desirable approach to take.
As you all know, a derivative action in the first place involves somebody saying the people on the inside are doing bad things. And so there's a pall over the entire litigation that would suggest that you want to be, as the old phrase goes, as virtuous as Caesar's wife. And you want to seem that way because the whole thing is about people inside the company are doing bad things. So that the more independent that you can be, the more independent you can seem, the better.
Who uses the Caesar's wife reference anymore? Who does that?
I told you that he was here partly for comic relief. He didn't hear that because he wasn't here yet. All right, let's move on. Constituent misconduct. Under what circumstances must an in-house attorney report constituent misconduct? As I said before, we're getting into a question of revealing confidences when we're talking about reporting misconduct, and really to an elevated level if you're talking about misconduct. And that is a frightening, a troubling concept for lawyers, because from early days we are all taught that an essential part of what we are and what we do is tied up, and in fact our ethics rules are largely based on the concepts of confidences and loyalty. That it is our role to take the confidences of our clients and lock them inside and never reveal them to anyone, particularly if that is going to be to the detriment of our clients. So the idea, the mere idea of revealing things that are going to be detrimental to our client that we only know because of the representation itself, whether that's as outside counsel or as inside counsel, is very troubling. But there are circumstances under which counsel are allowed in some cases to reveal such information, and in fact required in some cases to reveal such information. There are two sources for these obligations or these authorities. The first is with respect to public companies, the Sarbanes-Oxley Act, or SOX, and the second is the ethics rules in general. So let's turn first to the Sarbanes-Oxley requirements. Kate?
Sure. The Sarbanes-Oxley Act, you probably know, is 2002 federal law, section 307 of which mandated that the SEC issue rules prescribing minimum standards of professional conduct for attorneys appearing or practicing before the commission. And the SEC did promulgate such rules, and in doing so, it broadly interpreted what it meant to practice or appear before the commission. And so that includes anyone who transacts business with the commission. Basically, if you're representing a public company that reports to the SEC, you're going to be subject to these rules. And so Section 307 of the Sarbanes-Oxley Act directed the SEC to promulgate rules that mandate that an attorney report evidence of material violations up the ladder. And the SEC did promulgate such rules, and so those requirements apply to attorneys who practice for the SEC, in-house counsel at publicly traded companies. So what does it mean to report a material violation? What is a material violation? The SEC's rules lay out this definition, which you can see on the screen, of evidence of material violation, and it's kind of wordy, and I won't read it back to you, but basically, if it's reasonably likely that a material violation is going to occur, a material violation of securities law or a breach of fiduciary duty, you have an obligation to, as in-house counsel at a publicly traded company, to report it up the ladder, which means either to the head legal counsel, or if that's you, to the CEO of the company. And then if the CEO doesn't take appropriate action based on your disclosure, you then have an obligation to report to the audit committee of the company or to the board of directors.
Thank goodness for guidance that is as clear as mud. Not to conclude, a competent attorney not to conclude that it is reasonably likely that a material violation has occurred. If we didn't have this kind of language, I would be unemployed.
Yeah, let me point out that this is the first of a number of rules that we're going to look at with respect to reporting misconduct or revealing confidences, and they all have something in common. They are dense. They are complicated. They set out a number of standards. If you look at this one right now, what's the evidence of a material violation? Look at all of the triggers in this rule. First of all, there has to be credible evidence. As Mark said, well, at least we know what credible evidence is, right? Usually you have a jury to decide that, or a fact finder, based upon which it would be unreasonable for a prudent and competent attorney, which is yet another standard, not to conclude that it is reasonably likely, yet another trigger, that a material violation, another element or trigger, has occurred, is ongoing, or is about to occur, yet another trigger. There's it's a picket line of standards that have to be met until such time as you have the obligation. Of course, if you get any of these wrong, if you get 4 of them right and 1 of them wrong, you're going to get it wrong. It's a very difficult standard to meet. And if we move forward outside of the Sarbanes-Oxley context into situations that may not involve public companies, although public company, let me slow down. The ethics rules here would apply whether it's a public company or not. We see that the standards we're going to go through are similarly dense. So in Wisconsin, first of all, we have again the entity rule, the organization as client rule, 1.13. It applies to all attorneys, and it includes both reporting up and reporting out provisions. And I'm going to briefly, we don't have them in our PowerPoint, but I'm going to briefly read you the reporting up and reporting out provisions of Rule 1.13. First, reporting up. Unless the lawyer reasonably believes that it is not necessary in the best interest of the organization to do so, the lawyer shall refer the matter to higher authority in the organization, including, if warranted by the circumstances, to the highest authority that can act in behalf of the organization as determined by applicable law. That's the reporting up standard under 1.13. But there's also a reporting out standard. If the lawyer reasonably believes that the violation is reasonably certain to result in substantial injury to the organization, then the lawyer may reveal information relating to the representation whether or not Rule 20:1.6, which is the confidentiality rule, we'll get to that shortly, permits such disclosure, but only if and to the extent the lawyer reasonably believes necessary to prevent substantial injury to the organization. I lost count of how many elements are in that particular rule for when you are required to report out. And we go back and count them, but we won't. The point is, there are a lot of triggers that you have to go through. And 1.13 focuses essentially on the organization and the obligations to the organization and the potential for harm to the organization. But when we move from 1.13, entity as client, to Rule 1.6, the confidentiality rule of the Model Rules of Professional Conduct, we find that overarching both of these rules, both Rule 1.13 under the Wisconsin rules and Sarbanes-Oxley, we as attorneys here in Wisconsin have yet another set of rules that we need to be aware of and need to follow when it comes to revealing confidential information, including confidential information that may be related to misconduct by the entity. And first of all, what is most important for you to understand is that in Wisconsin, and this is not true in all of the states or jurisdictions, it's not true under the ABA model rules. In Wisconsin, there are situations in which it is not permissive but mandatory that you reveal information. I think as we move ahead, we'll talk about mandatory disclosure. As you can see, under Rule 1.6b, a lawyer shall reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary, there's that standard again, to prevent the client, a new element, the client, from committing a criminal or fraudulent act, another element, that the lawyer reasonably believes is likely to result in death or substantial bodily harm or in substantial financial injury to another. Okay, so when do we have to reveal confidential information? When a client comes to us and says, I'm going to shoot that guy at the deposition, and we happen to know that this guy has not only access to a gun, but carries one, and oh, by the way, he assaulted this guy who's going to be at the deposition before, we're starting to meet those standards that we see in this rule. But it doesn't necessarily have to be a situation where this rule creates, angst for us. In a situation like that. I always call this rule, the mandatory disclosure rule, the useful bludgeon. We have had situations here. I don't know if you have had them internally. I hope not. I hope you never do. But we've had situations where a client has come to us and told us that he is going to do something unlawful, something that may even be harmful, in the way that this rule contemplates. And when we've had those situations, they are very rare, I'm glad to say, my counsel is always that we should tell that client, you shouldn't do that, and by the way, I'm sorry, but if you really intend to do that, we're going to have to reveal that, presumably to the authorities. That's a useful bludgeon to get clients not to do bad things. We have an advantage, unfortunately, that you do not if you're dealing with your in-house client. We'll talk about some possible scenarios that you might have there, that we always are able or usually would immediately thereafter fire the client. It's harder when the client is your employer.
Well, we should point out that we're happy to reveal that no one in this room has had such threats from us.
Well, I don't know everybody in this room, Mark.
It would have worked its way to you, I suspect.
That's probably true. Okay, so permissive disclosure. This is a different standard. Rule 1.60, when may you disclose confidential information, even information detrimental to the client? And as you can see, under Rule 1.6c, sub 1 and 2, 1, you may do so to prevent reasonably likely death or substantial bodily harm. The element that's missing here that we saw in the earlier rule in 1.6b is that it doesn't have to be the client. So suppose this scenario. Suppose that you are an in-house counsel, which you are, and you are involved in a transaction or potential transaction in which your employer, your client, is targeting another company for purchase. And in the process of that transaction, you obtain in due diligence information showing that that company has or is about to release toxic waste into a public waterway. And you conclude that this is potentially and in fact likely to cause death or substantial bodily harm to anybody who is using that waterway, whether it's for recreational purposes or potable water, whatever it might be. This is a situation where you might be permitted under these rules, but not required because it's not your client to reveal that information. Now, you may have very good reasons to reveal it nonetheless, because if I was, frankly, sitting in your chairs in a situation like that, the last thing that I would want to do is sit on information like that and have the almost certain eventual plaintiffs who get injured not just sue the target company, but sue you because you knew about it and you didn't do something about it. But you have the ability, the privilege to reveal such information in a situation like that. Now let me change the facts a little bit. Suppose it's not the target company. Suppose as in-house counsel you learn that up at your widget plant there's been a breakdown in the pollution abatement system, and nevertheless the manager of the widget factory is saying, if I'm going to deliver those widgets on time to China, I've got to discharge this toxic waste, and I'm just going to discharge it into the local public waterway. Now you've got a different issue, and it's the different issue because now you're not talking about that target that maybe you've decided you don't care to buy anyway because of the way they run their operation, but now you're having that awkward conversation with your own executives. Now you're having that conversation with your own directors. And this is where you may find yourself in a situation where you've got to make some decisions of your public company. Do you have a SOX issue? You might. That might be a material issue. You may have an issue under 1.6c, permissive disclosure. You might even have a mandatory disclosure situation. So all of these issues, it seems to me, come down to one important practice tip, which is don't go it alone. In those rare circumstances where I get issues like this, internally or on behalf of outside clients, it is rare that I would try to figure this out on my own, because when I look at those standards, they are so dense, they have so many elements, they have so many triggers, and so much of it is, frankly, subjective. Mark?
You know, and even I was just thinking about how internally, beyond just this issue of reporting misconduct, how important it is that we, as counsel in this law firm, when faced with issues pertaining to, risk management, liability, things of the sort. I mean, our culture, and this is something I think should be happening in every, not only law firm, but in-house counsel organization. Our culture is transparency and openness to go to other people, not just on these issues, but I'm claims counsel, Fran is general counsel. We're oftentimes talking about issues between us, and it's very important that you tell your lawyers and your executives that particularly when they are in the middle of the particular issue, it's important to go to someone else because your judgment gets clouded.
Doesn't that beg the question, though, as
Okay, let me repeat that question. It's a very good one.
That's a great question.
Which is, if you're in-house counsel and you're finding yourself or feeling yourself in that kind of trick box, how do you get counsel for what happens next if you feel like maybe you're not getting a good answer from the people that you're reporting to? Can you come out and talk to us? Well, I guess there are a couple of options. One, you literally could, as an attorney trying to determine your own ethical obligations, you could hire your own counsel independently, and there would be privilege that would attach there in that situation where outside counsel is trying to advise you as to your ethical obligations. I would hope that a better solution would be that all of you have the commanding persuasiveness to tell your executives, your decision makers, whoever it might be, of the situation you are in when something like this comes up, and to use, as I put it, the useful bludgeon, to say, you're putting me in a position where I may have to reveal this. I know that doesn't make any friends, and trust me, I've been there. Internally here at a law firm, we'll have questions that will come up, as Mark said, in claim situations and liability situations. We haven't had this recently, but I think one of our peer firms here in town has had to deal with a lot of questions lately about emails and, what have they done with emails and have they produced the right emails in one of the big political cases that has been raging over the course of the last few years. These questions come up, and it's an uncomfortable conversation to have, but you know what? We're lawyers. We kind of bought that when we got into this profession. So I'm sorry I don't have a perfect answer for you.
Yeah, and if I may, this is a great segue into what we're going to be talking about next, where you have issues of representation of an entity vis-a-vis those of the individual. And I think that's the conflict, that's the difficult circumstance that you're talking about. And when in doubt, and we'll get to this here in a moment, it is best to avoid those conflicts by getting people separate representation. So you have to sort out where is it that an individual's interests divert from those of the entity that I'm responsible for representing. That is the fork in the road for then getting them separate counsel.
Mark, why don't you introduce our next topic, the so-called corporate Miranda?
The corporate Miranda Warning, right? And this is part of or comes out of decision, the Upjohn decision we'll talk about in a moment, but is also subsumed in the Supreme Court Rule 21.13F. A lawyer shall explain the identity of the client when it is apparent that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. So this comes up most often, always really, in my work in doing internal investigations, where there is some sense of wrongdoing that may be something imputed to the organization as a whole or to individuals who were acting inappropriately. So why is this an important rule, and how does it relate to this decision, this Upjohn decision we'll talk about in a moment, and some of the questions that have led us here? Because it is important to understand for the purposes of, one, preserving the privilege, and two, avoiding conflicts. And so preserving privilege sometimes requires that we have to go to get outside counsel, where your role as in-house counsel can get too commingled with that as business advisor, depending on what your role is in a particular fact situation, and in avoiding conflicts which require then a necessary disqualification for your own law firm, because they are sideways with individuals with whom they have also been giving advice on the same matter, also tells us, you know, we need to know when to bring that separate counsel into the fold.
Kate, why don't you pick us up on Upjohn?
Sure. Most of you have probably heard of Upjohn versus the United States Supreme Court case that, as Mark said, deals with these kinds of issues, advising constituents on when you do and you do not represent them, as opposed to representing the entity. In this case, involved an effort by the IRS to examine certain documents and reports that have been compiled by the Upjohn company during an internal investigation that it had conducted. So the Upjohn company interviewed many of its own employees as part of an internal investigation, and the IRS sought to have access to those communications and documents embodying those communications with employees, saying they're not privileged because the in-house attorney represents the entity as a whole and not these individual employees. And so the Supreme Court, in deciding how far this privilege extends, laid out a rule, and it's up here on the screen, a three-part rule to determine when privilege extends to communications with individual employees of an entity. And those are if it is communicated for the express purpose of securing legal advice, if it relates to the specific corporate duties of the communicating employee, and if it is treated as confidential within the corporation itself. So it's a pretty straightforward rule that the Supreme Court laid out in terms of how this privilege applies. And so how does that affect you? First, it does create some flexibility for companies to conduct internal investigations and know that the communications that an in-house attorney has with the individual employees are going to be privileged. But it also creates some tension, as Mark was saying, because pursuant to the entity rule that we've been talking about, only the company and not these individual employees can decide to waive the attorney-client privilege. And so although those communications between in-house counsel and individual employees are privileged, that employee has to know that it's not his or her privilege to waive, that it belongs to the entity.
And in this law firm, when we have those tricky situations that we need to sort through, and while we are maybe in some way quite capable of doing so, as litigators, claims counsel, general counsel, we'll often, though, go outside immediately and bring outside counsel into the fray, because we don't want to do anything that, notwithstanding what Upjohn is telling us, to do anything to blow a privilege in the course of deliberating and addressing the issue that might be occurring.
So we have some tips, we hope, as to what counsel ought to be doing regarding any internal investigation, including providing what we call an Upjohn warning. Mark, you have used such warnings.
I have, and if you go to the next slide, that'll give us, or maybe
I don't think so.
All right, earlier version perhaps did. And
sorry about that.
No, that's okay. That's okay. So what we do when we sit down is when we interview someone, is we tell them, look, we are representing the entity, not you individually. But I like to use the term, I differentiate between representing people in their official capacities as officers, employees, whatever, of an organization versus their individual capacity. I think people understand that. When you're there, your company counsel, they understand that distinction, and that's what I use. And we tell them that that the interviews that we're doing are confidential, that they shouldn't disclose any of the statements that they make to us or questions that we've asked them to other folks, because in every attorney-client relationship, the element of confidentiality is critical. And then we tell them that the company controls the confidentiality and the attorney-client privilege and the investigation itself, including the information that we discuss, and that it's attorney work product.
I'm going to move us forward a little bit here because we are, of course, running up against time already. But Kate yesterday actually looked at a case that I saw just yesterday in an advance sheet, and she pulled it up. Great example, and it's kind of a scary proposition for in-house counsel relating to not giving an Upjohn warning. Kate?
Yeah, this case came out of California just last month. It involved a claim by an employee, a machinist of a company, against the company because he had slipped and fell on some oil. There were two employees there, the one who slipped and fell and ultimately sued the company, and then another employee who witnessed the whole thing. And that witness was deposed in the lawsuit, and in-house counsel for the company was present at the deposition to defend this employee who had witnessed the whole thing in the deposition. And that the employee who witnessed it had told a couple different stories over the course of the investigation of the incident about what he saw, and he had been a little bit inconsistent, and he was worried about that, and he was worried about saying something in the deposition that would get him in trouble with his company. And so before the deposition, he said to in-house counsel who was representing him there, who's going to protect me? Am I going to get in trouble here? And I don't want to say the wrong thing. And in-house counsel who was representing him said, as long as you tell the truth, you're going to be fine. And I'm here to defend you in this deposition. As long as you tell the truth, it's fine. And the deposition went on, and the testimony that was elicited in the deposition was mostly related to the company. Just one story came out. But after the deposition, the company learned that this employee said some things about the company during the deposition that were a little negative, and also learned that the employee had told different stories at different times, and was upset about it, and it eventually led to a disciplinary hearing and this employee being terminated from the company.
First mistake by the company, but we'll go on.
And so that employee who was terminated sued the company for wrongful discharge, but then also in-house counsel specifically for malpractice. And on summary, the lower court granted summary judgment for in-house counsel, but the appellate court reversed and said that in-house counsel shouldn't have represented him at the deposition without telling him that I, in-house counsel, represent the company, and I don't represent you specifically. And so my obligation is not to you specifically to protect your interests, it's to the company.
So recognizing that this is a California case, and we all know that has some import, what we learned from this is that it's now actually there's an appellate decision saying that a malpractice claim can be maintained against in-house counsel in a situation like this, ultimately for failing to give an Upjohn warning to clients. Of course. That's right. All of that still has to be proved, and it may be that there wasn't a wrongful termination here, but you don't want to be in that position.
Can I ask another question? Going back to the
yes.
mandatory, I noticed there wasn't a case that you talked about. There probably aren't any cases where lawyers have been disciplined or because they didn't disclose something. I mean, the cases are few apart anyway.
Yeah, you're right. The question is, are there cases out there in which lawyers, at least in Wisconsin, have been disciplined for not disclosing confidential information? I'm not aware of any such disciplinary cases in Wisconsin. And I'm not aware of them elsewhere, but I've never looked elsewhere. Part of that, I'm sure, is because it's buried. It would be a very unusual set of circumstances where somebody could later prove that the lawyer did know about information that the lawyer should have revealed. I think in an era of much more significant disclosure and in an era of e-discovery where every email can be obtained, I would be a lot more concerned that such cases are coming if lawyers don't reveal information in certain circumstances. And one thing that I didn't mention when we were talking about disclosure was the mere fact that in Wisconsin and under SOX and under 1.13 and 1.6b, you're permitted to disclose raises a question that you should be thinking about. I guess I adverted to it when I gave that example. If you do know some information and you don't disclose, even if it's a permissive disclosure, not a mandatory disclosure situation, are you potentially buying some liability? Because something happens, somebody gets hurt, or somebody's financially damaged, and they can show later you knew about it, and they say you should have revealed it. We haven't seen that case yet, but I suspect it's out there.
I think you're seeing also coming up in some of the cases involving the archdioceses and Catholic churches, where in some of those instances, they were consulting with lawyers about how they should be against people, and the lawyers then were accused of not reporting or not sharing. Those are all playing out yet as we sit here.
Fair enough. Okay, we're going to move quickly forward. We're going to do a little eliding. I'm not going to talk, or we're not going to talk about licensure in Wisconsin. It's a fairly mechanical rule, 10.034F, and it's relevant to your organizations if you hire someone from outside the state who isn't licensed here. The thing to remember is that there is a procedure that makes it easier for in-house counsel to get licensed and that regulates what they can and can't do during that process. So we'll move past that. I do want to talk about an interesting case that came out this year related to that question. What happens if an in-house counsel isn't licensed? Kate, you want to give us a very quick rundown on this case?
Sure. This case is from the Southern District of New York earlier this year in July. And this case involved actually a Dutch in-house attorney. And in this case, the plaintiff deposed this Dutch in-house attorney who was unlicensed. And the defendants in this case instructed him in that deposition not to answer based on privilege. And the defendants relied on case law, with U.S. case law, specifically a case called Gucci v. Guess, a 2011 case again from the Southern District of New York, that says that communications with an in-house attorney who's unlicensed are nonetheless privileged if the client has reason to believe that the in-house attorney is licensed to practice. Because in that case, the Gucci case, the communications were with an in-house counsel who was formerly a member of the California Bar, whose admission had recently lapsed, and was still holding himself out to be a licensed attorney. He was recently doing things like filing papers with court, and he didn't tell his client, the company, that he wasn't licensed to practice anymore. And so because the client had reason to believe that he was licensed, those communications were privileged.
By contrast, in the Anwar versus Fairfield Greenwich case, the court ruled that there was no reasonable expectation that the in-house lawyer was actually a licensed attorney and therefore would not honor the privilege. So something to be very careful about if your organizations have lawyers that the organization knows is not licensed, particularly if they're not licensed anywhere, but even if they're just not licensed in the jurisdiction in which they're practicing. I think we'll conclude. I'm going to move way ahead, and I apologize again that we have to elide some of the topics we were going to talk about, but I think that the email issue is something that is probably very interesting to you. I don't know about you, but every once in a while I'm asked to look at employee emails here, and I was telling Kate earlier today that I actually used to have some kind of an app on my desktop that would allow me to look at any email I wanted at any time. And it is in my interest, and probably somewhat in your interest, as I told Kate, for every employee here to think that I read all of their emails all the time. But of course that's not true, because if I did try to read all their emails all the time, I'd shoot myself, you know, because it would be either so boring or so appalling or, you know, something that I wouldn't be able to stand it. But the idea out there that maybe there's somebody looking at emails is always a good idea for those of us who practice in litigation and claims and know what a bad email can do to you. That being said, a real question arises as to in what situations can you look at emails? Are there any ethical constraints on doing that? And I'm not going to take too much of Kate's thunder here, but essentially it's going to come down to reasonable expectation of privacy. Most of us at this point in the maturation of technology, I think, understand, and most employees, I think, understand, and most entities have policies that say the employer's email system is the property of the employer, and you don't have a right to privacy on that email system. If you don't have that policy, or if you're not sure if you have that policy, I recommend that when you go back to your offices tomorrow, you may want to pull up your technology policy or your privacy policy and see what it says. But I think most people now do expect that their employer has a right to see what they're doing on the employer's system. Where it gets a little tougher, and there's an ABA opinion that says, and this is opinion 11460 from 2011, that essentially says, yeah, that's true. And in fact, an employer's counsel doesn't even have an ethical obligation to tell an employee's counsel when that inevitable case develops between employer and employee, doesn't even have an obligation to tell that employee's counsel that the employer's counsel has the email and has read the email, because there shouldn't be any expectation otherwise. Where it gets more interesting, we'll move forward here, is what about a personal email account? For those of you who don't know what I mean if I have a Gmail account or a Hotmail account, or as a matter of fact, earlier today, I was looking at my home, I think it's called Earthlink account. Why was I looking at it? Well, my mother happens to be ill, and so all my brothers and sisters and I are communicating about that, and it's just a lot easier to do that on that email, that personal email, where we all have address lists, and I access that through the internet, as other people can do as well. It's not an email client on your system. It's not your employer system. But if I send an email message on my Earthlink system, but I use a computer here to access the internet so that I can then send that email and read that email, okay, is that something that the company, that my law firm, that your entities, your employers, do they have a right to look at those emails, those personal emails that I have? Kate, what does this case say about that? Sure.
Well, as far as New Jersey is concerned, the attorney who gets access to these emails between an employee and her attorney does have an obligation to, first of all, notify the employee's attorney that he has access to those communications between the employee and her attorney, and then also to turn him over, because that's what the New Jersey ethics rules require.
I don't even know how you would actually access those things, and I don't know technically how you would access them. If somebody could here at our law firm go in and look at the emails on my Earthlink home email account that I read today or that I sent today, I don't know, but I guess it must be possible. The question is, can you do it? And there is an ethical constraint to doing that under this New Jersey case, and it gets worse. Kate?
Sure, yeah. Another state, North Carolina, said that it would violate that state's ethics rules if in-house counsel was to advise its client, the employer, to access personal emails of its employee by doing something like changing the password of the personal email account of that employee. Fran said, he doesn't know how it would be possible to get personal emails of an employee, and I don't know either. I don't pretend to know how that works, but if it involves changing a password on, say, a Gmail account, at least one state, North Carolina, says that would violate ethics, that state's ethics rules.
And the ethics rules that North Carolina is looking at are ethics rules that we have as well. It's not specifically about emails. It's specifically about dishonesty and deceit, and that opinion concludes that such activity would be deceitful. Now, what you might want to do in this respect, the first thing you need to do, it seems to me, is your entity needs to decide, what is our philosophy about this? You may decide it makes more sense for us to say, you know what, we are not going to assert that we have a right to see those personal emails on a personal email account. In fact, we're happy they're on a personal email account, not cluttering up our own company's email system. God knows if you're like us, you're trying to figure out how to have fewer emails because the cost of keeping all of those things on your servers is incredible. And if you're not keeping them, then you have to, be addressing it through a records retention, records destruction policy, which is also difficult to maintain and costly in its own way. So you might decide that's the approach we're going to take. We're going to allow people that consideration, and we're not going to assert any right to see those things. But if conversely you decide, no, we think it's more important, it's more in the entity's interest, that we make it clear that if you are using a computer or even the Wi-Fi network at our company to access your personal emails or anything else on the internet, we have a right to see what that is. Well, then you better make sure that your technology policy makes that very clear, that your privacy policy makes that very clear. We've covered a lot of ground and not as much as we wanted to, of course. It's after 5, and we really appreciate your attention. You've been good, so we will allow you to go have a beer, those of you who are here. Mark?
Closing remarks by...
Oh, yeah, and thank you. We have another guest here that we want to introduce, Mark Sablejack, who's the publisher of the Business Journal. Mark, it's been a while since I've run into you.
It's been a long while.
Something like I was probably backing you down in the post at the time, yeah.
Successfully dunking over me. So, well, welcome everybody. I know you had a long afternoon and learned a lot, and we appreciate partnering with Reinhardt on this event. This is a prelude to a very exciting event we'll have on noon on Thursday, which is our Top Corporate Counsel Awards, the second year that we'll partner with the Association of Corporate Counsels, the Wisconsin chapter, and firms like Reinhardt to host these awards. What we do best at the Business Journal is really inform. And one of the ways we can do that is by hosting awards programs. What awards programs do is shine a spotlight on individuals, often behind the scenes in an organization, that really make the business or the organization work. We're going to hear stories Thursday about individuals from Trek Bicycles and some of the other large corporations, Snap-on and others. I think they're really fascinating stories about the inner workings of a business and what role the general counsel and the corporate counsel plays in those organizations. And for someone that didn't come up through that vein, but who worked with corporate counsel at the Journal Sentinel for 18 years, I had an appreciation for the role and the many duties that can often fall to that individual or those individuals within a company. So, we're looking forward to anointing another group of 11 individuals and as I said, shining a spotlight on that role in a corporation. We'll have, this is our last awards program of the year. We'll have one more large event this year, which is our Power Breakfast in December 13th. We're going to have Tom Long, the CEO of Miller Coors, speak to our group, and then next year start all over again with a brand new series of awards programs. And what we ask is if you have nominations, if you want to nominate yourself, go right on ahead. We're great having any kind of nominations. We'd love to see this program continue to grow. This is the second year for these awards, and I think we're thrilled with them. So thank you to Reinhardt for doing this. Thank you for being a partner on Thursday in these awards programs, and look forward to a great 2014. Thank you.